So let's just start off by talking a little bit about the ground that we're aiming to cover. So we're going to give you a bit of an introduction to this idea of employee ownership and what we've abbreviated to EOTs. I don't know if you've come across that expression before, an acronym for employee ownership trusts. We're going to look at why some law firms might be interested in adopting this model. And we can give you some names, which we will do, of various firms that we know that have already gone down this route. We're going to talk you through the process, what's involved. There are some tax reliefs associated with employee ownership trusts, which are very important to be aware of, although we always say to any business we talk to, please don't just choose employee ownership because you like the idea of the tax reliefs, and I'll build on that a bit later on. Andy's going to talk about the SRA authorization process. Then we're going to let you have a short case study about a real live law firm that has gone down this route quite recently. And then we're going to have some time for questions. So hopefully that all makes sense. Starting off with a little bit about us, I'll keep it brief, but what we do in our legal practice is help businesses achieve greater long-term success through employee ownership. So we're a specialist practice helping companies become employee-owned or more employee-owned than they already are is what we do. And we're also 100% employee-owned ourselves. We've been in business for actually almost 21 years now. And then I've put down there some other information about us, including the fact that we've worked with about 140 firms over the last few years in becoming employee-owned across a very wide range of sectors, actually, definitely not just law firms. And obviously we're regulated by the SRA. There's a picture at the bottom left showing us celebrating our 20th birthday, which was last year. So we thought the next slide might well be interesting because some research was carried out in 2023 and the results were released in October last year. The research was commissioned by the Employee Ownership Association, which is really the trade body for companies that are employee-owned, although it was independent research. And what it found was that there was some quite significant positive impacts on business performance from employee ownership. Now, I emphasize that this research looked at business across a range of different sectors. But just picking out some of the things that they found, employee-owned companies are more productive than companies that are not employee-owned, somewhere between 8 and 12%. And we think there are about probably over 1,700 employee-owned businesses in the UK. So that 1,650 number very likely to have gone up since October. And over 50%, employee-owned companies are over 50% more likely to be expanding their workforce than other companies. 83% of employee-owned companies reported an increased employee engagement with what's happening in their business. So a few pretty significant and quite striking results from that research, which we thought you might be interested in.
Robert, could I just chip in there quickly? Just there's an anecdotal story that was in the legal press yesterday, just to mention as well, specifically about law firms. There was the firm Ice & Harrison reportedly making the legal press, doubling turnover, increasing turnover 16% in the second year of employee ownership, and the staff getting a healthy bonus as a result. completely anecdotal, not as good as your empirical data,
No,
Robert, but it's
yeah,
interesting to see it in the press and sort of the successes. These anecdotal success stories is quite interesting, and we are seeing those in the legal sector.
yeah, no, that's really useful. And Ice and Harrison seems to be becoming quite a well-known company to have gone down this route. It's covers multiple offices mainly in West Yorkshire, I think, and covering a very wide sort of full service law firm covering a wide range of services.
And it's worth saying their turnover was already sort of 19 million, so they've added 3
Yeah,
million. So if you're turning over 100,000, it's easier to add 16%, but if you're already turning over, circa 20 million, it's quite impressive.
we've got a link in a minute which you'll be able to access if anybody wants to look at that story. It's coming up in the next slide, but one, so we'll
Oh,
see that.
sorry.
See that? It's like no, it's all right.
Got
No,
excited.
it's actually it's good that you raised it. I think that's the perfect time. I won't dwell on this. This is just a number of companies that we work with. As you can see, it's a very wide range of different sectors. And then looking at law firms, yeah, Ice and Harrison. We've put some other ones down here. There are some that we're aware of, and some that we've worked with that want to, for some reason, want to keep it confidential that they've become employee owned. So we obviously haven't named those, but there are some others you may be familiar with. At least one or two of those, maybe more of them. And then if you want to read that story about Ice and Harrison, then when you get the slides, you can see the link there. So why would you consider doing this? What are the attractions of employee ownership as a law firm succession solution? And I'd definitely start off by saying we're not claiming this is the right structure for every law firm. There is definitely scope, and it's entirely appropriate that there should be a number of different ownership structures to suit different firms, different needs and circumstances. So we're not being kind of highly evangelical about employee ownership, but we do think for a number of firms it might have some attractions. So here's a slide which sort of sets out what those might be. If we start at the top, I'm just going to work my way around briefly, going clockwise. So simply keeping the firm going often can be an attraction. If you want to avoid having to invest in runoff cover, in shutting a firm down, you want to keep it going, then an employee ownership trust may well help you do that. It also has the attraction of permanence. So once you've made a transition to employee ownership, it can actually be quite a simple ownership structure with very few moving parts. So in the future, there's no need to make arrangements really for new owners to come in and old owners to depart, because a trust structure just basically means that isn't necessary. You can include a special bonus arrangement or equity arrangement for key people. That's perfectly possible and permissible. We would say it's often a really good platform for growth, further growth, and improved performance. And then linking to that, moving to the bottom, it can increase employee productivity and engagement. And we saw some stats about that a couple of minutes ago. I would say the modern law firm increasingly relies on the skills and commitment of a broader range of people. Obviously, the lawyers are really important, but it's not just the lawyers. And I think that trend is going to continue. An ownership structure which gives other people a stake might begin to look more and more compelling. There are some tax breaks. We'll come back to those in a minute. And then also there's no need for anyone to make a personal investment. So we often find in talking to firms that what they say is that what might previously be the next generation of partners, current associates, aren't really able or are unwilling to make a personal investment in becoming an owner. So what is employee ownership? What does it look like? So if you have an employee ownership trust, which is really what we're talking about this afternoon, then you have that trust holding the shares in the company which runs the business. If you're not yet a company, but a partnership or a limited liability partnership, then we'll show you what would need to happen in order to become a company. So that trust holds the shares on behalf of all the employees. So when could it be suitable? An employee ownership trust or EOT could be potentially suitable when you're confident that just culturally employee ownership feels like a good fit with your business. If you're looking to achieve ownership succession, you've evaluated all the possible approaches to that, and employee ownership comes out top, then obviously you're going to look at that pretty seriously. Important that you have leadership team support for it. So I think that box would definitely needs to be ticked, and also important that your employees are engaged in the idea that they're going to become owners of the business through a trust. When might it not look so attractive? If it doesn't really feel like culturally employee ownership will be good for the company, then certainly it's going to be more of a challenge, or you might have some work to do to make it look more like a compelling solution. If the plan is to pay out the current owners, then as we'll see in a minute, normally the funding for that comes out of the profits of the company. And if there isn't planned to be a strong flow of cash and profits, it's going to be difficult to fund the purchase price. If you don't have support from your management and senior associates, also that's not going to help. If continued independence isn't viable, then you might be better off looking at finding a third-party buyer if you can, or having a discussion with, I think, what's now colloquially known as a consolidator. And if there is a prospect of a third-party sale to someone with very deep pockets and maximising sale proceeds is the goal, then maybe you go down that route. A law firm with a significant international footprint might find employee ownership a little bit harder to manage. You've probably got issues in a range of different legal jurisdictions to take into account, although I wouldn't rule it out. Finally, if you're confident that your traditional model of partnership or LLP is going to continue working well, then if it ain't broke, then there's nothing that needs to fix. So let's talk a little bit more about employee ownership trusts. So they were created in 2014, probably now about 1,700 in the UK. The number is growing quite quickly, doubled between 2020 and 2022, and the employee ownership brings 2 tax reliefs. More of that in a minute. So how do you transfer ownership in a practice to an employee ownership trust? Sorry, skipped a slide. So if your firm is already a company, then what you would do, this very briefly run through this diagram step by step, having first set up your employee trust or employee ownership trust. The current owners would sell their shares to the trust at a price based on an independent valuation. The company would then immediately become owned by the trust for the benefit of the employees. So that ownership change would be immediate. However, the payment for the shares that have been sold to the trust is likely going to take place over a period of time. So that's step 3. The trust pays the purchase price in instalments. And then step 4, Where does the money come from? The answer is it comes from the company out of its future profits. So you might typically have a period of years in which the company pays a contribution to the trust, and the trust then uses that to make an instalment payment of the purchase price. If you're not a company, you're a partnership or an LLP, you'd first need to incorporate. So the existing partners or members would transfer their ownership to a company, in exchange for which they would then become shareholders in that company. So a little bit about the tax reliefs. What is often of significant interest to owners is that it is possible to sell your shares in your company to an employee ownership trust and without paying any capital gains tax at all. So there are some conditions attached. First is that your company must be trading. The employee ownership trust has to benefit all employees. So this is for everybody working in the company. And it must acquire more than 50% of the company. And then you must have a minimum number of employees compared with the number of selling shareholders. Sort of probably oversimplifying this requirement, you would need to have, if you had 2 selling shareholders, then you'd need to have at least 5 employees, and applying that 2/5 fraction. So let's say you had 3 selling shareholders and 5 employees, then the legislation would say you haven't quite got enough employees to be able to claim the tax relief. Once a company has become owned by an employee ownership trust, it can then pay an income tax-free bonus to its employees each year. So there's also something in it for the employees, and the maximum amount per employee per year is £3,600. I think pretty much every company that we've worked with is finding some way of using that facility. Very immediate and obvious and important benefit for the employees. So being very practical, what are the potential risks and problems? We've looked at the upside. What are the potential risks and problems, and how do you avoid them? Well, one potential risk is that your employees just aren't interested in the fact that your company has become employee owned, in which case you probably couldn't expect to see any great performance benefits arising. So really important to engage your employees, really important to make sure that your leadership team is on board. Make sure that you do invest time in planning the governance, for example, the terms of the trust, terms of purchase of your shares, how it's all going to be funded. And to make sure that you don't get on the wrong side of the SRA, then you must involve them in this ownership change. If you're retiring as an owner, then you should be willing and able to let go, carefully do your own financial planning, and accept that the timing for paying out may need to be flexible. So if profits dip in a year, that might mean you have to wait a bit longer to get your money. Right, my final slide before I hand over to Andy. This really just sets out the key steps and timings. I'm not going to go through these in fine detail. You will again be able to see these when you get a copy of the presentation. But overall, we generally say allow around 6 months for the transition, and that includes allowing time for getting advanced clearance from HMRC and also getting advanced clearance from the SRA. So I'm going to stop sharing now and hand over to Andy.
Hey, so do you mind if I ask a quick question before we do that, just from my curiosity? So based on what you're saying, then it sounds like we're saying that I'm sure there's no typical law firm EOT candidate, but the sort of firm who might best be suited to, there's a certain amount of scale involved. So it's not just you and your sort of your PA, because that's not going to work. It needs to exist without you. And I think also we talked before about de-risking, maybe an interest in taking a bit of money off the table and not reinvesting it, and presumably some sort of succession plan as well. Those seem to be, am I right in saying those are sort of the main characteristics based on what you've said?
Yeah,
Maybe wanting to step back or wind down.
I think so. Yes. It's not going to it's not going to work in a micro business with no employees or hardly any employees. Certainly, the tax reliefs aren't going to be available. And yes, the kind of elephant in the room at the moment so far, which we'll come back to a bit later on, is we've talked about ownership succession. We haven't really looked at leadership succession. So if you're an owner and you're also running the business, then yes, an employee ownership trust enables you to de-risk financially. But if you eventually want to stop being involved in running the business, which I'm sure you will do, then you need to have a leadership succession plan in place as well.
Yeah, and that's the same for anyone who's looking to exit or sell a controlling share. Yes, everyone needs to make sure that there's still something that's going to run without you, or there's a very clear plan to sort of get there. So thank you very much. Sorry that I'm the one prepping you with questions. Let me bring up my slides. Is that showing up okay? Can you see that, Robert? Yeah, great. Yeah. Okay. So there's one or two things that Robert touched on there that's worth getting into. So obviously law firms regulated by the Solicitors Regulation Authority, and they will, yeah, typically one way or another, you'll need to think about how your structure is approved and authorized by the regulator for this. It's not something that I think people should look at with any great dread or horror. Yes, it can be a bit time consuming. Yes, it is a process to go through, but it's not one of those scenarios ordinarily where we have any concerns about will the SRA ultimately approve it. This is an existing law firm after all. It's more a question of going through the process and thinking about the implications that are involved from the SRA side. So hopefully nothing to put anybody off, but it is really important considerations. Just quickly expanding a little bit on me. So I'm Andy Donovan. I used to work at the SRA once upon a time. I also used to work in private practice some time ago. And since leaving the SRA, I founded the Compliance Office Consultancy. We work with law firms on sort of small to medium-sized law firms on monthly outsourced compliance support. We also offer things like AML audits for firms of all sizes and one-off projects and training and that sort of thing. Anything SRA compliance we work on. And we're just about to celebrate our 10th year, which makes me feel old as to how long it's been going for and flown by. And we recently, a couple of years ago, joined the Da Vinci Works group. So getting into this topic, in terms of an employee-owned trust, how does that relate as regards the SRA? The first thing I would say is that if you need to convert from an LLP or partnership to certainly converting from a partnership to a company, there is a streamlined process at the SRA. You don't have to follow the usual processes if you're setting up a whole new law firm. But for other applications, the process is quite similar actually to that new law firm setup. So it will depend upon your circumstances, but anything is possible. But what I would say is if you're converting to a company, you do need the SRA approval of that. And then once you're looking to go into the EOT model, so that's to say to have essentially a trust owning a majority share in this business rather than yourself, typically that means that you're going to have an incorporated trust and there will be non-legally qualified, i.e. non-lawyer and not a law firm, ownership of the shares in the business. Whenever that happens, any non-lawyer partner or member of an LP or director, any tiny 0.00001% share of a shareholding in a company owned by something that's not a law firm or someone that's not a lawyer recognised in the UK to do the restricted activities, then you're talking alternative business structure. When we say that, what I mean is you're still a law firm, and many firms, if they're already a company, they can keep the same structure, but what they need is to go to the SRA and say, look, at the moment, we are owned and managed by lawyers. Please give us permission to be partly, or even wholly in some cases, owned by non-lawyers. So even if the people who make up the trust are all legally qualified, it's likely, depending upon how you structure it, you're still going to need to be an alternative business structure and get that license, get that approval before you do any changes. I think the SRA is starting to issue sort of fixed fines and things for people who are making some administrative slips around telling the SRA that this has happened or that's happened. You don't want to fall into that camp. Get their agreement before you start moving around shareholdings and things. Once upon a time, EOTs were a rare beast for the SRA, and they were sort of, getting to grips with them, and everyone was working together to sort of work through the process. They're more familiar with it now, and certainly we've done a number of them now and are pretty comfortable on setting out exactly what the structure is, and I'll go through that in a bit more detail shortly. Just to go back a step, so what is an alternative business structure? As I said, if you're going down the EOT route, the chances are you'll probably need to get that approval. It's still a law firm. It's regulated in virtually identical ways to other law firms. As Robert said, there'll be some people who become an ABS and you won't necessarily know about it unless you go and check their registers. It won't be obvious. So all we mean is that there's some sort of non-lawyer ownership or management on the board, involving, as I say, the non-lawyers. In a traditional law firm, everyone is a lawyer. In an ABS, that won't be the case. Structurally, the requirements are all going to be essentially the same. So you still need to retain at least one lawyer at director or partner or membership level. If it's an LLP, you'll still need someone with more than 3 years experience post-qualification, and in practice, a lot more than that, typically to satisfy the insurers. You need to maintain some sort of non-legally qualified involvement in the business throughout. So actually doing it structurally with this incorporated trust can be a way to make sure that you don't run into difficulties. I sometimes worry that some firms that have become an ABS in order to, for example, make a finance director a partner in the firm, they may not appreciate that if that person then retires, they're in breach of the requirements because they're no longer eligible to be an ABS. So we need to bear that in mind. Just having difficulty moving slides for some reason. Right, I've started to touch on this. So as I was saying, in terms of, what does it mean to be an alternative business structure or an EOT ABS regulated by the SRA? Almost identical rules and guidance. There's no distinguishing. You're subject to the same codes of conduct and the same provisions and policies and procedures that the SRA expect to be in place is exactly the same. You don't have to put on your website or your letterhead that you are an ABS, also called a licensed body. The main difference is simply that you are a law firm that has been approved, gone through the process to have these non-legally qualified owners/partners. And also, you do have the option to provide non-legal services alongside legal services under one roof, called an MDP, a multidisciplinary practice. That's probably for another day, that topic. Mostly today, we're just talking about changing the ownership model. But just to say, once you're an ABS, you do have some other options as a business if you wanted to bring other people in under one house to, for example, offer accountancy or something alongside your legal services. The one thing I will just mention about SRA ABSs is that for firms with very significant turnover, maybe 25, 30, 50 million turnover, The SRA is currently the investigator and the enforcer of first instance decisions. So for some strange reason, we had a regulatory disciplinary regime set up for traditional law firms and solicitors under the Solicitors Act 1974. And then when ABSs came along, within that legislation in the 2007 Legal Services Act, they set up a separate set of disciplinary provisions in which not the Solicitors Disciplinary Tribunal, but the SRA is the one with all the power to make fines and remove people from working in those types of law firms again. That typically hasn't been all that relevant, but just to mention, the SRA is fining ABSs as a percentage of turnover. And for firms with very large turnover, touch wood, you're never going to get into any trouble with the regulator. But the fines at the moment, should things go wrong with anti-money laundering or whatever it is, they're looking quite aggressive and quite punchy. Right, what will the SRA be checking? So when you submit the application, we prepare all of the various forms, which I'll go into. They're going to want to make sure all their usual checks are sound. So they're going to want to make sure that you're running a compliant firm, etc. The advantage of being an existing law firm is that you can use your existing compliance procedures, COLP, COFA, MLRO, MLCO, any other of these crazy acronyms that I've forgotten. You can recycle all of those roles. For law firms which are already a company, you can probably just keep your same entity, keep the same entity, keep the same SRA number. That's quite a straightforward way to become an ABS and an employee-owned trust if you're already a company. If you're not, you can transfer first, or you could potentially transfer in one go, theoretically. But Robert may tell me that that's maybe not the best way to do it. It might be better to do it in stages. The trustees of the trust, who will be effectively majority share owners of the company in the future, if you went down this route, they would need approval. Now, the lawyers are likely to be deemed approved for the most part. That's going to be fairly straightforward. Non-lawyers, if they're sitting as trustees on the trust, they're likely to need approval, but it's not, they're looking for an absence of bad. You're not trying to prove that you're suitable necessarily for this role in a positive sense. They're checking that these individuals haven't got criminal convictions, haven't got problems like that. So generally speaking, we do not need to put all staff through the approval process. In fact, it's never happened and I can't see it happening. So although the staff benefit, the ownership and control is held by the trust. So it's the trustees that the SRA look at when they're approving these applications. In terms of the process, so when we're working on one of these, we will do a reasonably thorough covering letter to the regulator, setting out, just reminding them or advancing our case as to how this structure sits in for the purposes of the statutory tests and the SRA rules and regulations, in order that we can make their life easier, make our life easier, hopefully speed up the process, get ahead of anything and just say, look, this is how this structure fits into your approach. You need to approve these people, not these people, and here's the associated forms. That can be really helpful. And then all of the SRAs, rather silly names for their forms, FA1, FA2, FA3, etc. So FA1 entity form, FA2 individual approval form. If you needed our help with it, we would deal with all of that for you. And then any criminal records checks that are needed. They always want to see a structure diagram and sort of accompanying documents around, assuming it's available, any HMRC approval letter is always helpful, plus corporation documents and things if they're available. The insurance should just continue from your existing practice. And indeed, if you are a company and already in the right model to become an EOT ABS, then the insurance will just continue for that entity. And so that's usually straightforward. I've never known the insurance premium to be impacted in terms of the EOT side of things. And we've talked about before that there's a more streamlined, more straightforward. If you're already in ABS, then it's much easier. The application is much simpler because part of it's already been done, and you're just getting this trust approved as a suitable owner. So in terms of the actual process for dealing with the application, so it's submitted through the beloved MySRA system, and you can upload it there. And the SRA, they have a service level of about 90 days that they try to work to internally. We are hearing rumours that ABSs, since Axiom Insight debacle, are perhaps being treated with a little bit more caution. But generally speaking, we find, certainly when we're involved, it's vast majority of ours get dealt with within that 90 days, even with the more complex ones like an ABS EOT. The SRA, they always have questions, but as I say, I don't think this is a scenario where we're saying, will they approve us, won't they? It's fairly, it's a sufficiently well-trodden path now for us all to have comfort and be confident that they will approve it. And it's just getting through the process, answering those questions, and making sure that anything they do raise or have concerns about is dealt with appropriately. But touch wood, we've got 100% success rate for the submitted applications in this area. That's everything that I wanted to run through in terms of the SRA side of things. I'm very happy to take any questions from the chat, or if anybody wants to say hi, or if indeed Robert wants to get his own back and ask me any difficult questions, by all means, fire away.
I might ask you one question, Andy, which is, if you had an employee ownership trust where all the trustees were lawyers, would you still need SRA approval for that?
You would, assuming that that there's a corporate incorporated trust. So assuming that there's a corporate that's holding the shares, you would, yes,
Yep.
which I understand will almost always be the case. Theoretically, you'll correct me if I'm mucking this up. Theoretically, as I understand it, the unincorporated trust wouldn't have any separate legal personality. So the shares, the legal title to the shares, would be held by the individual lawyers, in which case it seems you wouldn't be an alternative business structure. So
Okay.
to the extent that it's feasible to do it and advisable to do it, yes. But in our experience to date, they've all been incorporated trusts, and they've all been alternative business structures.
Yeah, brilliant. Yeah, we'd always recommend having a corporate trust, because it gives the trustees who are going to be performing the role as directors of a specially formed limited company considerable additional legal protection in case they should get something catastrophically wrong.
And presumably because you're having employees coming and sitting on those, or at least an employee, they could be quite nervy, etc. So presumably that protection, is desirable from their point of view as well. Yeah. Coming in, someone perhaps no experience of running a business or that sort of thing before.
Yeah, exactly. It gives a lot of reassurance. A question's just come in on that in the chat, but I think we'll come back to that when we get to the Q&A, if that's okay.
Sorry, I will just answer that actually. So the question, sorry.
Oh, you go for it, Andy.
Yeah, as we're on a flow on the SRA. So the question is basically, presuming an ABS would always be needed due to administrative staff, because all employees are brought in as part of the employee ownership trust. Is that correct? So it's a great question. So what I would say is that no, not necessarily, because The tests for becoming an alternative business structure is all about whether you hold an interest in the business, whether a non-lawyer holds an interest. And what we're talking about here is the employees would benefit from this, but they wouldn't be the ones legally holding the shares or having the power with the voting rights over the big decisions. That's going to be the trust. All of the ownership and control sits with the trust. And therefore, when we put these applications to the SRA for approval, we're not getting all of the staff approved as suitable to own and manage a law firm. We're getting the trustees approved. And the SRA, certainly the ones we've dealt with, they've never suggested that all staff need to be approved. And so hopefully that answers the question, Sarah, but by all means, tap away if there's anything else.
Okay, thanks very much, Andy. So I'm going to move on to our case study example. You're possibly going to look at the company that's profiled and think, well, that's not a very original choice of business. We'll do a case study on ourselves. But we had a pretty careful think about what would make a good case study, and we thought, well, actually, as a firm, we've spent many years advising companies on how to become employee owned, and then we got the sort of surgical implements out and started operating on ourselves. We did learn from that, actually, and we also, what we aimed to do was, having learned from some of our clients about what they'd done and what had gone well and what things there were not to do. It's always an evolving process, isn't it? Being an advisor, you're always learning, and sometimes you learn from your own clients, and we certainly do that. So we thought, actually, as a kind of distillation of what might make a good employee ownership case study, we wouldn't be a bad example. So yeah, that's the reason for kind of appointing ourselves as the case study this afternoon. So a little bit about
plus you can tell us all the juicy details that you couldn't otherwise share, but for client confidentiality.
Well, yeah, we'll come on to one or two of those in a minute. Yeah. So I'm going to think of one or two things not to do, which we have seen happen. Just park that thought for a minute. So we were founded in 2003. We incorporated as a company in 2013. We got to a point where we had 4 shareholders, 2 significant ones, 2 smaller ones. We definitely have always had a flat structure in terms of decision making. We're pretty open and collaborative. Our plan was always to extend ownership to all the staff. And originally we were going to do that through personal share ownership, but we decided that an EOT offered a simpler structure and also an opportunity for the founder shareholders to de-risk, to use that term again. What did we do? We started planning actually back in 2019. Then COVID came along, and that did require a switch of focus. I'm sure you'll all be familiar with the kind of issues that we faced. And initially it was just kind of, how do we make sure we keep the show on the road when suddenly we're all working from home? And that really became our main focus for a couple of years. We then came back to planning our EOT in 2022. So I put down a quick timeline of what we did. We had an initial valuation in February, and that was really just to sort of give us an idea on whether, from a financial point of view, it was going to stack up. We engaged the compliance office in April. We did some modelling of our cash flows to ensure that the EOT was fundable going into the summer. We then engaged our staff in the design of the EOT. So not every business does this. Some owners feel more comfortable in doing all the planning themselves, and then they tell the staff about the plans to become employee owned when everything is pretty much in place, or certainly when when they've completed a kind of design phase. So perhaps before they've actually got into the legal documents. But we looked at what some other companies had done, and we decided actually we get a better result if we got our staff engaged in the process. So, for example, looking at questions like who the trustees would be, we discussed that with the team, and various other things as well. We then applied for HMRC clearance to make sure the tax was going to work as planned. We checked our EOT readiness. So as a team, were we kind of emotionally ready to become employee owned? Were the main shareholders ready to give up control? We did involve some external consultants to help us with that. I think the feedback from the team here would probably be that wasn't awfully useful, but other businesses might find it more useful than we did. Then we prepared the documents, we got the valuation finalised, we got SRA approval in place, and then we completed in March last year. So as one example of something definitely not we would recommend not to do, so much if you're planning an EOT and then you go through the implementation and then you only tell your employees after it's actually happened, that probably isn't going to be the best way of getting them engaged as owners. So at the very least,
do people really do that? They're setting up a
some,
trust that concerns the whole business
yeah,
and hasn't told anybody.
yeah.
What about the trustee that's got to sit on the board for
Well,
the
they may not have an employee. They may not have an employee trustee, so that might because you don't have to. It's a good idea because it's an employee ownership trust after all. But they may decide they don't want to have an employee trustee. They want to keep it all under wraps, and then it's something that's being done to the employees rather than that they're kind of buying into, and that's probably not the best start. But yes, we have seen it, not in many cases, but once or twice, yeah. So that's our timeline. So where are we now? Our EOT now owns 100% of the company. The purchase price will be paid over 6 or 7 years, starting March last year. We have 2 employee trustees, 1 founder, that's myself, and we're shortly to appoint an independent trustee who will require SRA approval. 2 directors continue to run the business day to day. Yeah, we'll talk about leadership succession in a minute. The financial reward for employees currently is a salary plus an annual bonus, some of which is income tax free. So I've just noticed a typo with the closing bracket there. We very much do feel that it encourages a collaborative culture, and the phrase I find myself using increasingly, it creates a strong following wind in much that we do. So it doesn't feel like it's a great effort to ask people to do things. In fact, increasingly, they don't have to be asked. They're kind of already doing it.
That's a really great point, because sometimes, small to medium-sized business owners do sometimes not complain, but just sort of see that, the team aren't necessarily giving what they're giving, and to which the obvious answer is, well, yeah, because you're getting all the profits.
Yeah,
and
exactly.
you're literally own it. It's yours, and it's really interesting to hear that. From your point of view, that possibly shifts somewhat.
Yeah, I've certainly noticed a change. I mean, that's not to say that we don't have a next challenge, which is the last bullet point there, of leadership succession, because I'm the managing director of the business. Longer term, I plan not to be playing that role, so that's the second part of succession. Yeah, that's the kind of next stage which we're starting to think about. And the point is you can separate the two, so you can do the ownership succession and then you can sort out the leadership succession over a longer period of time if you wish to.
Well, we've got a great question from Carl. He actually touched on something I was thinking because you've gone with 100% ownership by the employees, by the trust for the employees, benefit of the employees. And I was just thinking it might be worth stressing you don't have to give 100%. You can sell 50.1% based on what you've said. But Carl's question is, to what extent are the selling shareholders allowed to continue being involved in the management fee earning of the firm? But it sounds as though if all you need to sell up is potentially a very slim majority of ownership and control, and you're certainly still heavily involved, presumably you don't have to go all in, so to speak. It doesn't have to be big bang.
No, you don't. Fit minimum 50.1%, as you say. So some owners like to kind of hedge their bets and say, well, I'd like to retain an ownership stake because we think the business might continue to grow and I can have some residual stake in that. You can continue being involved in both the leadership or management of the business and the fee earning. So there's no requirement to step down at all from that if you don't wish to. So
presumably then, so sorry, well, let's take a hypothetical. Presumably then, somebody who sold 100% and was still managing director, still running it, they're an employee.
Correct.
Yeah. Okay.
Yes, they'd be an
So you
employee.
can still
They'd
be employed to run the business if the trustees determine you're still the best person to do it, I guess.
Yeah, absolutely right. What might feel like a big change is that you're no longer controlling the company. This is a really important point to make sure that owners are clear about. So the trustees, as the controlling shareholder, they have ultimate control of the company. So, for example, they decide who the directors are, and if they think a director's underperforming, then they have a right to make a change. You can, as a selling shareholder, have a little bit of residual control. So, for example, until you've been paid, you can say if the company wants to do certain things on a list, then it will need the permission of the selling shareholders. So that will be things that are outside the ordinary course of business, or maybe acquiring another practice, something that might involve spending, unusual amounts of money. So to that extent, you can have a little bit of residual control, but
that
not
sounds a
beyond
bit. That sounds a bit like an earn-out period you sometimes get in a more traditional exit if you sell the business, and then there's an earn-out where the remaining consideration, the payment for the sale, is dependent upon performance, and so the sellers understandably say, well, don't torpedo the business while don't do anything that I think is going to torpedo the business while I'm still trying to get paid for the sale. Thank you very much.
Yeah,
But
it's the very same. Yeah.
But the point you were making around earlier, I suppose that's the key thing, isn't it? Is you do need to be comfortable saying goodbye. I mean, I founded a company as well, and I think people have different levels of emotional attachment, and I think it's difficult to. Yeah, I think you do need to get comfortable that you're going to be okay one day saying goodbye to this. But I think I think most people don't want to work until they drop, if it's sorry to be crude. Most people do want a plan, and a lot of people also reach a point where they want to make a change and want to take a step back and maybe want a bit more balance or whatever in their life and de-risk, etc. So but being able to say goodbye, it is important. It's good not to sugarcoat that bit.
Yeah, no, very important. So we've got 2 or 3 minutes left. If bit of space in the chat, if anyone wants to post any more questions, then we've got a little bit of time to respond to them. So do go ahead. In the meantime, I'm going to ask a question which we often hear from companies we talk to, which is what's the main risk of going down this route? What could go wrong? And Probably in terms sort of financial terms, the main risk is that the business takes a downturn and doesn't generate the profits that were anticipated. In that situation, the risk for the seller or sellers is that they're going to have to wait longer to get paid out for their shares. So it's yeah, always very important just to be clear about that risk. Another risk is the kind of one of lost opportunity, which is that if you don't make the effort to engage your employees in the fact that they're now the owners, then you can't expect to see any performance benefit in the business. I've got a question here. We've used EMI schemes on top of EOTs to entice the leadership. Any reason this wouldn't apply to the legal sector in the way it does for other industries? So the answer to that, Sarah, thank you for your question, is in a law firm, unfortunately, that's and it's actually quite annoying this because we couldn't do it in our own practice. And a law firm is one of the excluded trades for the purpose of EMI options, which have certain tax breaks. So you can have share options, but they can't have this favourable EMI tax status. But there is an alternative form of option called the company share option plan, which has similar tax benefits to EMI. And generally, a law firm would be eligible to have those kind of tax advantaged options instead.
Great. Okay. Should we wrap up there, or is it? I have one final question, but if it's time, if we need to wrap up,
let's squeeze it in, Andy. Yeah.
Well, I was only going to say, I thought I'd heard someone, I don't think it was in the chat here, ask a question about whether instead of waiting for profits, a sizable, substantial company might be able to get a loan to pay out the outgoing owner.
Yeah.
Is that something that's realistic or ever happens, or is it only for a specific sort of?
That is possible. Yes, we have some EOT projects where the company's taken out a bank loan, which has funded a much larger initial down payment. So if the company meets the lender's borrowing requirements, then that might be feasible. A lot of companies are turned off by the high interest rates at the moment, so that can also be a factor.
Well, that's a good point. Yeah.
One more, if we could squeeze one more question in from Chelsea. I'm going to let you look at this one, Andy, if that's okay.
Yeah, sure. I'm happy to do that. So if an existing ABS, if you have an existing ABS and that ABS has one shareholder, how many staff need to agree? Does it require all staff? If I'm understanding the question correctly, and if I've understood Robert's talk correctly, you don't necessarily. I think it sounds as though you ought to get staff buy-in, but it's not as if they need to sign on a dotted line from what Adam and Rob was saying and say, we're going to go ahead with this. I think you need to be satisfied it's going to work. From an SRA viewpoint, if you're existing ABS, all you need to do is get the trustees and the trust, if assuming it's incorporated, approved as new owners. You don't need to go through the ABS process. You're probably already a company in that situation, in which case get the trust approved. You don't need the staff approved. You don't need their express agreement, from what I've understood what Robert said, but you would want their buy-in, I think, in practice for this to work. So an existing company ABS, pretty straightforward in relative terms.
Yeah, exactly right. You don't need formal staff permission. It's not like you're giving them a contract to sign and saying, do you agree that the company should become employee owned? It's more like you need them to know what's happening and feel that they're going to support it, and they feel like this is a good idea and they're enthusiastic about it. So that's what you really need to achieve.
Good. I'm glad I was paying sufficient attention to
absolutely.
To get,
you've been listening, so that's much appreciated.
The final question is, what do people do from here in terms of next steps? If anybody wants to learn a bit more or anything, what's their best move?
Do feel free to contact either of us directly. if you would like to have a further conversation to explore the feasibility, or just find out more, that'll be fine. We also are going to publish in a few weeks' time a guide to employee ownership trusts for law firms. So we will send you a copy of that as well. So I think that, Andy, unless you've got anything else to add, we
Have you
would
got a
say,
slide with contact details? Presumably everyone's got contact details for you. I presume that's yeah, okay. Or I can put it in the chat.
yeah, I mean, it will come through when we send the presentation through. But there we go. Those are our contact details.
Great.
So you will get
That
those
looks very
sent through.
professional.
Excellent. Okay.
Good.
All right.
Thanks very much,
So,
everybody. Thanks for all the great questions. It was really helpful. I hope you found it useful. And thanks obviously to Robert Postlethwaite for hosting. I enjoyed it.
yeah, thanks very much for listening and attending. I hope you found it useful.
Thanks, everybody. See you again.
Take care.